So here we go. Shireen Abu Aqli was killed a month ago by an Israeli sniper while doing her job as a journalist. She was covering one of those many Israeli military invasions to the West Bank city of Jenin a month ago. While you may have read or heard about this incident, I mentioned this today as introduction to my presentation about teaching human rights in Palestine to present two ideas. I noticed that many were seeking an explanation to what happened. Why would the Israeli military kill Shireen? What is the message they want to deliver? What would killing her realize for Israel? I have had it with such questions and the unchecked assumptions that the occupation and apartheid regime in place is necessarily, for those who ask those questions, is necessarily considered rational, and actions undertaken by its soldiers necessarily fit in its larger scheme of colonization. That kind of ordered and rational regime, which is usually attributed to what is Western, liberal, and democratic. I was also completely disoriented to hear people questioning why Shireen was there at first place. What was new this time for her to go to Jenin, to be there? Was she wearing the flak vest and helmet? Was she in the right place with other journalists? All questions that not only blame the victim, but repeat somehow unconsciously the assumptions about us in contrast to them. Palestinians, Eastern people, Oriental, uncivilized, chaotic, who, while being killed by a sniper with the best technology, are suspected always of being blameworthy, just for being there, being who they are, regardless of what they did and their actions and deeds. The second point out of this incident I would like to raise is what some have dubbed as the merchants of doubt, which works perfectly in our case in such cases of targeting killings of protected persons under international humanitarian law. By raising doubts to the point that the victims themselves need to have clear evidence of their being victims before blaming the perpetrators. The way to do it is simple. Show the inconsistency of any account, that something is fishy, that there are many possibilities and many explanations that are possible, and that it doesn't make sense that the most civilized army in the region would do such a savage killing. Then the international media, out of them trying to be neutral, would need to present all points of view, that we need to give equal space for all opinions. And meanwhile, we count on the matter to die gradually. A wise friend told me, whenever something becomes hot in the social media, for example, give it 3 days. Something else will come up and people will forget. So here we are, after a month of her killing, another victim, a new day, and unfortunately we need to move on. But is this right? Let me share with you some of my perplexities and questions as a professor of constitutional law. Sometimes also I teach human rights courses to graduate students. I'm now doing that as a full-time faculty member at Birzeit University. I did that as a visiting professor in Bethlehem University, and I'm doing also as adjunct professor at the University of Saint Joseph in Beirut, Lebanon. I started teaching constitutional law and human rights law at Birzeit University when the latest legislative and presidential elections took place, that is in 2006 and 2005 respectively. In classroom, we talk about rule of law, human rights protection mechanisms, separation of powers. We talk about legislative prerogatives, executive powers, and the independence of the judiciary. But in the outside world, there is something else. The West Bank and Gaza Strip are not a state. They are occupied territory. Palestinians aspire to convert those territories into a state. They have started the theatrical appearance of the state since 2012 General Assembly resolution. when they refer to Palestine as a state instead of entity. Gaza Strip is completely separated from the West Bank. Palestinians need Israeli permit to cross from one area to another. Palestinians, for that purposes, based on the military orders, are considered in the other area as foreigners. It doesn't mean that other Palestinians are considered citizens. One group is considered foreigner and the other is resident in the area where they have been born as Palestinians. The West Bank is fragmented into cantons, separated by settlements, roads, infrastructure connecting those settlements and connecting Israelis and excluding Palestinians, considered residents tolerated by military orders in their own country. Millions of Palestinians are unable to cross back to Palestine and effectuate their right of return. They are held in limbo in many Arab countries, not being able to enjoy civil, political, and economic, social, and cultural rights because they are Palestinians, and for that same reason they are unable to return to Palestine. What Palestinians see outside classroom is anything but rule of law, equality, separation of power, protection of human rights, etc. They see houses demolished, minors and women targeted and killed, checkpoints mushrooming, liberties curtailed, discrimination institutionalized. You got the message. I will not go on with those details. The question I pose every day is the following: what is the relevance for teaching human rights in a country that is under occupation? What relevance it has to teach human rights and democracy in a country where the national authority in place is governing undemocratically, using dictatorial prerogatives, unaccountable and unchecked authorities? What is the relevance of teaching human rights in a country where other norms prevail, cultural and religious, such as those governing the status of women, minorities, etc.? How can we balance between human rights and national rights? Rather than giving a theoretical elaboration about possible answers, I will share some of the issues I had personally to deal with, where the dilemma for us Palestinians, Palestinian academics, teaching human rights is presented at its highest level. In the course on constitutional law, for example, we refer to the Constitution as in the books, texts, and official journals. The way things function in real life is different. So what is constitutional law that I need to teach? What the text says or what the government does? We learned and we now teach that human rights are by definition universal, for the same fact that they are rights related to human, and humans are the same everywhere. Human rights are accordingly not dependent on local contingencies. But the way rights are distributed by states' authorities and applied by international bodies offer completely different messages. The Palestinian Authority tried to impose, this is another example that I was interested in, tried to impose a social security law by decree law that aims in the declared objectives to ensure a dignified life for Palestinian workers. A Birzeit University Institute was even commissioned to review the draft law. People went en masse in the street as never before. They don't trust that this is a law that aims at ensuring a right, but a way through which the authority in place will find a source of income by stealing the money of workers. The decree law was suspended. We as professors and academics, we were in a limbo. Shall we support the social security law or not? When President Abbas signed a decree and later on ratified the Convention on the Elimination of All Forms of Discrimination Against Women, many Palestinians, including Palestinian women, were in uproar. Many lawyers, including our graduates who took many courses on human rights, were upset for this kind of what they call westernization of Palestine. And the attack reached many trainers and academics on their personal capacity, because they took a position in favor of adopting that convention and applying it in Palestine. So is really the status of women and women's rights and non-discrimination of women something Western, or does it apply to Palestine too? Is there a contradiction between human rights and religion, between human rights and culture? Whenever there is an attack, this is another case where we had to decide what to do, including suicide bombs targeting Israelis. The question is raised whether international humanitarian law and international human rights law gives a carte blanche for Palestinians because they are under occupation to kill civilians. Some will object, of course, that since Israelis serve in the military, they are legitimate target of the resistance. But is resistance a right to those under occupation, including resistance by using the force against the occupation and the population of that country? Is force used by resistance groups subject to international humanitarian law? Are we really two parties in conflict? Give me just a second, I'll take off a notification here. Okay. Now, when the so-called Palestinian leadership made a choice, a strategic choice, they would say, to internationalize the conflict by ensuring a UNGA resolution and act as a state in the ratification of treaties, including international human rights law and international humanitarian law treaties. And also they ratified the Rome Charter establishing the International Criminal Court. Were they really enhancing human rights protection for Palestinians? Or was it a counterproductive move? Because not only the situation of rights did not ameliorate, the national rights also were damaged, because we were since then talking about two parties in conflict, as if the conflict is over some more or less territory, as if the war is between two armies with the same armament capabilities and accordingly under the same rules for possible accountability under international law. I personally have been commissioned to write a report about law and human rights for Palestinians in East Jerusalem, annexed illegally by Israel. The questions raised there was whether we should support Jerusalemites' use of Israeli court system to resist aggressive acts against them and their properties. Here is the dilemma. Whether they should participate in municipal elections or not, whether schools in East Jerusalem should accept the oversight role of Israeli education system as a precondition to receiving governmental subsidies or not. I mean Israeli subsidiaries. In case they don't, they risk not being able to stay there and serve the community. If they do accept that kind of challenge, they risk being part of the what we call Israelization process of East Jerusalem. The same for Palestinian hospitals not being able to serve the community because of the financial restrictions on Palestinian hospitals. So they need every day to make a choice whether or not to make certain moves with the Israeli health system or not. I'm also, as was mentioned, a board member of the Independent Commission of Human Rights. We needed to ask ourselves, when the Legislative Council was paralyzed in 2006, whether or not we should have a say in reviewing presidential decree law, the system that is the only track to adopting laws in Palestine since 2006. So here's the dilemma. If the Independent Commission of Human Rights does not have a say, then decree laws will be adopted and it will be very difficult to make a change. And the decree laws may become regressing or going back on some of the human rights protection that we have. But in case the Independent Commission of Human Rights intervened and reviewed decree laws, unfortunately, they were considered by many Palestinians and many academics as being part of that autocratic regime that is in place since then. Now, as board member of Al-Haq, as was mentioned too, that is a human rights organization working in Palestine since the 70s. This organization had to deal with the Israeli occupation since then. Now, recently we had to deal with the attack that Israel had on civil society organizations, using the anti-terrorism law in Israel. and military orders in the West Bank, rendering Al-Haq and other 5 Palestinian human rights organizations unlawful under Israeli law and Israeli military orders. Such organizations needed to decide, and I was part of the discussion, how to proceed with their mission in ensuring some kind of documentation of violation of human rights, whether by Israel or by the Palestinian Authority, and how to continue to use international law and mechanisms to ensure accountability, including building a case for the International Criminal Court. The question, however, was the following. It wasn't easy. What and how Al-Haq will function in case such laws will lead to shrinking financial and budgets from the donors who are unable to do anything with Israel, including EU funding that started to be suspended because of unproved decision and based on any proven criminalization by Israeli authorities. Other questions we raised whether we should use the Israeli military and Israeli court system to object and resist such decrees. So many Palestinians believed we should not go and legitimize the Israeli Ministry of Defense and its committee and the Israeli court system because we know the output, so we shouldn't deal with the system, including also not going and object the decree by the military order. So we were in a dilemma whether or not to use the system in place, which is a system of apartheid and occupation and colonial regime, in order to resist such unlawful decision and illegal decision against Al-Haq. Another case when dealing with personal status law and Sharia law or customary or tribal law in Palestine. I had to work on all those issues in the past. Usually the attack in the literature on Islam as being regressive society or religion, or Arab culture as being a retarded culture, of course compared to the Western culture. But is it really so? The question is, what is really Islamic and Arab about what we now call Sharia and customary law? How do those reflect historical contingencies in which colonial, and I mean here British and French in specific, are partly responsible to the way Sharia and customary law is now? When I teach human rights protection course for the Arab Master in Human Rights at San Joseph in Lebanon, I always give enough space to the critique of current regime of human rights, including those critiques that focus on the correlation between international law and colonialism, international law and imperialism, whether in its older and current format. So for us Palestinians, the development of international law since the Second World War and the development of human rights regime within the so-called Never Again movement was accompanied by the unfortunate honoring of the international community of unlawful promise done by the British authority to establish a homeland for Jews in Palestine. Not only that, but also to establish a state for Jews in Palestine, to the exclusion of the rest, the native, the autochthon population. Roles are switched. Yesterday's victims are today's perpetrators. The international community was not neutral. They are responsible to what happened to the Palestinians and to what happened to Palestine. So here is the question that I end always my discussion with my students. Shall we or can we give up on international law and the international community for those same reasons? To what extent Palestinians can use international law and international mechanisms as a forum through which to advocate for their rights? Is there a different path other than international law and current regime of affairs in the international community for Palestinians that they can follow? Recently, you may know that EU is imposing a clause in all EU contracts, and some member states start to follow the EU lead as a condition for funds to reach civil society organizations and universities. And here I'm talking about an experience as part of the administration at the University of Birzeit. So that's so-called the anti-terrorism clause. The problem, however, is that most Palestinians And most Palestinian factions are on the terrorist list for the EU and, of course, for the US. So here is the dilemma. If we don't sign, some other organization, you can create even new organization, are ready to sign. And the funny thing is that the Palestinian Authority itself, they don't mind to sign those clauses, that clause. But the community in Birzeit University, I mean faculty member as students, as much as the board members of Al-Haq and the ICHR and many respectable organizations, they refuse to sign the anti-terrorism clause. Not because we are not against terrorism. We are against terrorism. We believe that we are subject to terrorist acts by the State of Israel. But because we refuse to normalize what the EU and the US is doing, to normalize that resistance groups, Palestinians, are considered terrorists. And we refuse by signing the anti-terrorism clause to normalize that fact. But what alternatives do we have? Because many civil society organizations, many universities, unfortunately, are dependent on international funds. The last case I would like to mention is related to the so-called BDS, Boycott, Divest and Sanction. You may have heard about it. The BDS is presented by many as one way forward, as an alternative to the so-called strategic choice of internationalization of the question of Palestine that the Palestinian Authority had started. We are not talking here about imposing tariff restriction on settlement products as the EU is proudly announcing that they are doing. We are talking about boycott, divest, and sanction to Israel, not because it's a Jewish state, and not because it's a state where the majority are Jews, but because it is an apartheid state, because of its settler colonial regime in place, because of the continued nakba on Palestinians. Many important and internationally renowned supporters of Palestinians and the rights of Palestinians are still discussing, and unfortunately they are still rejecting the BDS as way forward. Of course, they reject the extreme version of BDS that do not distinguish between those Israelis and Israeli institutions against settler colonial project and apartheid and the rest. So what is the right thing to do? In case some advocate for BDS, is it part of the freedom of opinion and speech, or should states sanction those acts as propaganda, as anti-Semitic, as Germany, for example, and Austria are doing right now? And accordingly, considering that kind of propaganda for BDS or the advocacy for BDS to be considered anti-Semitic. Here are some of the dilemmas and questions. In the discussion, I hope I can respond to your question. And if you are interested about any of the issues and the questions raised, I may be even ready to respond how we acted. Because it's different. We don't find an answer in a book. When you are in the middle of a crisis, you need to decide what to do. And the best thing you can do is like improvise. You try to do something. You are not sure that this is the right thing to do, but at least we made some choices. We will wait and see the result on human rights protection. We will wait and see the result of our choices on the national rights. But we had the opportunity, and this is empowering, to make some choices. The problem remains for those many choices Palestinians are still denied to do. Not only those who are present in the West Bank, but also for those who are unable to go back to Palestine. So here is more or less what I had in mind as a presentation, but I'll be ready to respond to any of your questions about any of the cases I referred to, and without reading, so I'll be responding spontaneously to your questions.